Good to start the recording. Thank you so much. So welcome. We are so excited for the information that's going to be shared today and having this conversation around not only leading up to WEAAD, but also sharing some really important information around enduring power of attorney and so much content that Ms. Eleanor Carlson is going to share today. So welcome, everyone. I would like to start with a brief land acknowledgement. So if you don't mind going to the next slide, that would be great. Thank you. So as we gather from across the province, the Alberta Elder Abuse Awareness Council would like to acknowledge that we are on traditional territories in Alberta, the many First Nations, Métis, and Inuit who have lived in and cared for these lands for generations. We are grateful for the traditional knowledge keepers and elders who are still with us today, and those who have gone before us. We make this acknowledgement as an act of reconciliation and gratitude to those whose territory we reside on or are visiting. I am personally honored and privileged to share this journey and embrace all opportunities to engage in and demonstrate leadership towards reconciliation. So thank you and welcome, everyone. So as we get started, I would like to, before we introduce our guest speaker today, for those of you in the room, I understand that there are some new folks, which is so exciting. But for those of you that aren't familiar with the council, we're going to use an acronym AEAAC. So if I refer to AEAAC, it's just to save a little bit of time, but that is the Alberta Elder Abuse Awareness Council. So Eleanor, if you'd like to go to the next slide, I'll just give actually, we'll talk briefly about WEAAD, my apologies. So for those of you who are familiar with WEAAD, the WEAAD will be celebrated on June 15th. And it's an international day to acknowledge the significance of elder abuse as a public health and human rights issue. And we, as some of you know, will be giving you a bunch of links throughout this presentation today. And there is a link on the AEAAC's website that has a toolkit for anyone that's interested. There's posters, graphics, to basically go along with our theme this year, which is grow the conversation, taking action against elder abuse. So we will have a bit of a conversation at the end of today's session, talking about maybe some different events that are happening in your areas, different things that you can do in your community. So we'll have a conversation at the end of this session around, growing the conversation, different things that we can do. But just so all the folks in the room are aware, we do have a toolkit that's accessible on our website, and I believe it's up in the core platform as well. And thank you, Stephanie, just put it in the chat box. So you'll have a ton of links that you'll be able to access today. So Eleanor, if you want to flip to the next slide. Thank you. So the Alberta Elder Abuse Awareness Council, we shared the 20-year anniversary in 2022. I am the newly appointed education coordinator. I started at the end of March. So my information will be given provided at the end of today's session. But for those of you that are familiar with the council, and those of you that are not familiar to the council, please feel free to check out the website. I don't want to take up today, too much of today's session going over that, but please feel free to check on the website. The link is below. But we are a council, throughout Alberta, dedicated to increasing awareness and supporting a community response to elder abuse. We have a province-wide network of professionals representing communities all across Canada, to promote the well-being and security of older adults. We work to increase community awareness. Some of those, training opportunities and awareness tools are, programs such as taking action against elder abuse. We have an information session and training available for what's called the It's Not Right, Neighbors, Friends, and Family, another excellent resource to bring to your communities and to provide more awareness. And there's also a toolkit on our website that I encourage everyone who hasn't already accessed that toolkit to please check it out. There's printable, downloadable versions, and it's just such a wealth of information throughout with the website. For any of you that are looking for training or education opportunities or anything around, information around in the area of elder abuse or anything else that comes to mind, please feel free to reach out to me. I do work throughout the whole entire province, so please don't think you're too far. I'm located in Calgary, but we can certainly provide supports and resources to anyone throughout the province. Okay, so reach out. We'll provide all of our information at the end. Thank you. And the next slide, I would like to introduce, oh, that's okay. So I think we missed one slide. Charlene, if you would like to speak on the CORE platform, the CORE Elder Abuse Group, and the work that is currently being done within the Power of Attorney Committee. And I know there's going to be an infographic that everybody is going to be able to access at the end as well. But I'd like to introduce you to Charlene Sitar to give some information around CORE and all the amazing work that's being done within the committee.
Thanks. Thanks very much, Elizabeth. So in 2022, so first of all, let me just talk about CORE. The elder abuse team within CORE was established shortly after CORE Alberta was developed and has now become something called Healthy Aging Alberta. So it really is a one-stop shop for everything elder abuse and senior related within that CORE Alberta platform. Many of you are probably members of the CORE Alberta platform. If you're not already a member, please consider joining, and it's an easy process to join the CORE membership. Within there, you'll see different topics on senior related issues, and one of those topics is elder abuse. So I've been part of the elder abuse CORE team since the beginning when we started. And it's a wonderful opportunity for all of us who are doing this work to address elder abuse in the province to come together collaboratively to talk about elder abuse and to find some solutions and provide some advocacy for changes. So that's about CORE Alberta, and you can find out more by joining the CORE membership for sure. So along with that work that we've been doing in 2022, the Alberta Elder Abuse Awareness Council launched a comprehensive study on the Power of Attorney Act across the province. And this was sent out to a variety of individuals, people in a variety of sectors, legal, law enforcement, healthcare, mental health, anyone who was working with the older adult population in our province. And so the goal of that survey that they sent out was to gather insight on some of the challenges that people maybe had experienced with regard to the Power of Attorney Act, and also to help have a better understanding of some of the positive impacts of it as well. The survey findings, as Liz had mentioned, can be found within a link that will be shared with you. And so the more detailed specifics and insights on what was gathered in that information can be seen in that infographic. So through that process as well, the council worked with stakeholders to form a Power of Attorney Committee, which again has a variety of stakeholders. And we've been working to come together to take that information that was gathered through the survey and develop a list of short-term and long-term goals that we're hoping to accomplish. Some of those short-term goals are, providing education opportunities such as this to service providers and also the general public, pardon me, to help people have a better understanding of what power of attorney documents are, and the importance of them, and also what the impact can be negatively of not having people, the appropriate people named in those documents can be. The long-term goal for us is to find an opportunity to encourage appropriate Government of Alberta ministries to look at potential changes to the Power of Attorney Act as the needs of the changing needs of our older adult population in our province morphs and changes. So we have lots of goals, we have lots of hopes, and none of it takes place in a silo. We look to collaborate with people on finding these changes and gathering these insights. So I hope that gives you an idea and kind of where we came to today as well. This presentation today by Eleanor is part of that plan to educate and bring awareness about power of attorney documents and their uses to everyone. So thank you very much, Liz.
Thank you so much, Charlene. Okay, so without further ado, I would like to introduce our guest speaker for today. Ms. Eleanor Carlson is a recognized wills and estates lawyer who takes a forward-thinking approach to the practice of estate law. Eleanor utilizes her deep knowledge of the practice area to craft personalized legal solutions that combine creativity with strategy. From personal estate planning to navigating high-conflict estate disputes, Eleanor is committed to empowering her clients during the legal process. She wants her clients to have a comprehensive understanding of their legal issues and their rights and responsibilities as they engage with the legal process. Eleanor also understands the sensitive nature of estate law and strives to bring both empathy and pragmatism to her work. Upon graduating from law school, Eleanor received the Faculty of Law Silver Medallion and has since obtained the Trust and Estate. So Eleanor, thank you so much for joining us today and providing the information to all of the folks here in the room today. I had the privilege of meeting Eleanor, probably about over 6 months ago, and I am just so excited to have her here today with us to share all of her information and knowledge. So welcome, Eleanor, today, and you can take it over.
Thank you, Liz and Charlene, for the intro. I'm assuming you can hear me because I don't appear to have a mute button on anymore. So I'm really excited to be here today. As Liz set out, I do estate law. So and I really try to have a broad practice. And what that means for me in this practice area really means, it's not just about estate planning, it's knowing the other sides as well. It's the litigation, it's the estate administration, and it's the guardianship and trusteeship side. And what I think that does, and having that kind of big framework, allows for a really textured discussion about how these different documents work in place. So when I say estate planning, what I'm really talking about is that incapacity planning, so that those powers of attorney that we've heard about, but also some other documents that I'm going to review as well, personal directives and supportive decision-making documents. One of the reasons that we decided to ask at the beginning, at the outset, of who's coming in the room, is I really wanted to make sure that this presentation and something Liz and I talked about is it tailored to our audience. So who am I speaking with? Of course, I'm standing in my office in downtown Calgary, and I don't know where you are and where you're coming from. So that was really helpful to have that all in the chat box. And what I'd like to do is, because I want to make sure I have a presentation that makes sense for you. So I'm planning on going over power of attorneys from a general high level, kind of, and incorporating into it some of the some discussion around how you as individuals who are working with our aging population can engage in conversations with them about why these documents are important, who they might be considering for the appointments in them, how they work together, and then what are the alternatives? So if we don't have those documents in place, what does it mean from a capacity perspective? And kind of going a bit, maybe a little bit deeper on that incapacity assessment stuff, but generally just kind of the scope of this area from that incapacity planning from the legal side. There is a chat box, which I think many of you have noted. I believe it's Stephanie who's managing it, because she's been dropping in some links. So please feel free to use it. I'm happy to have an organic conversation. If questions come up that work well, let's answer them when they show up. But someone might have to stop me, otherwise I'll just keep talking. So feel free to interrupt me, Stephanie, if you think that's an appropriate thing to do at the time. All right, so as I said, what we're going to do is review incapacity planning documents, supported decision maker, personal directive, and enduring power of attorney, and go briefly into adult guardianship and trusteeship and what that means. So this is who I think is in the audience. healthcare providers, accommodation providers, support workers, advocates for the elderly, financial services. So this is what I was so happy to see when I saw that go into the chat box. So we can, I think, just get going. Because I'm a lawyer, I have to give a little bit of a preamble about what I'm about to talk about. My goal is to provide legal information, not legal advice. So we really think about that in the law world as legal information being, you know, what does the law say from kind of this, whether it's in legislation or the facts about it. But then when we have to apply it to clients, it becomes legal advice. And really, no two clients are alike, especially when we're talking about incapacity planning documents. A lot of time these documents are thought about as boilerplate or quite similar, but when I am drafting them with people, I go into this deep dive of what clients have as assets, their relationship, income and tax history all can play a role depending on the complexity of what we're trying to accomplish for the goals of the clients. So it really does require that conversation. And what I love about this area is that it lets me have these personal relationships with my clients where I get to know all about them and create documents and set them up for success. So that's my disclaimer that encouraging clients to speak to a lawyer who does this area of law is really important. It's a little nichey. It's not a general practice area, particularly in the drafting side. So encourage them to speak with someone about incapacity planning. It doesn't have to be me. There's lots of great lawyers here in Calgary and across Alberta. And if you're in another jurisdiction and you want a name for a lawyer in another jurisdiction, I can help you. And if another area of Alberta as well, I have lots of contacts. So what is incapacity planning? So when we speak about it from the legal perspective, we are talking about it from the idea that we're setting in legal documents that would be used to prepare or as kind of as a worst case scenario, we lose capacity. These we have in place. So we don't have to go through court means to get someone to help us to make decisions for us when we aren't able to make our own decisions. So when we think of legal capacity, it's the ability to make decisions for oneself that have legal consequences. So we'll go into this a bit more, but at a high level, the power of attorney really is that financial side of it. And the personal directive is the everything else. So it's the healthcare, the accommodation, also really important personal decisions. And then when we use the word capacity, a lot of people, particularly those in the health sector, will refer to it as medical capacity, and that is distinct from legal capacity. Legal capacity is a lawyer question. Medical capacity is from that healthcare perspective. From the legal side, there's a presumption of capacity, and that's really important in our law that we assume that people have capacity at the outset. And this is important and becoming more and more important. I pulled this from the Alzheimer's Society of Canada. 1 in 8 Canadians over 65 will be living with dementia in 2025. And of course, that is a medical diagnosis that often, affects capacity and is part of this proactive planning. So one other just high level note about legal capacity is that I'm speaking from the Alberta perspective. Now we have many jurisdictions across Canada, and every single jurisdiction has its own legal documents and its own legislation that applies to creating powers of attorneys and personal directives and estate planning, estate litigation generally. So every province is different. There's a lot of similarities and lots of the judge-made law. So that's the ones where we are in the court system and the judge is making decisions on what and making drawing guidelines and about what different terms mean, like capacity. But when we look at that case law, we still have to apply it within the framework of our jurisdiction. So if you have clients across the province who have capacity concerns or it's something that they could expect on the horizon, then figuring out about their assets and where they have their assets is an important conversation, partially because they might need to have incapacity planning documents in different provinces so that they're better set up to be able to deal with assets in the different provinces. So proactive planning, and this is what I was saying just moments ago. And when we think about it in this presumption of capacity, perspective, we're really trying to start at the place where people have personal autonomy. And we start there, but it's also about being proactive and protecting vulnerable people. So whether it's from an education perspective or thinking about oneself. So that's why we often think about capacity on a continuum and why we have all these different documents. And these are the three that I'm mainly going to talk about: the supportive decision maker, powers of attorney, and personal directives. So they're on a range of different types of powers that you're giving to another person, but also relate to the level of incapacity and the level of autonomy that wants to be maintained with the client. So if we're thinking of all three of these documents as their commonalities, one important commonality is that they take effect when you're alive. So they are documents that we're creating. They may take effect, they may not take effect. They require some sort of incapacity and for some of them, or some sort of direction as to who can step up and help me in case to others. But they have to be completed before you lose capacity. So when we think about the legal capacity, what we're trying to do is, for me at the outset, I'm trying to say, does this individual have the legal capacity to create these documents? Which is why if you have clients with a diagnosis that has a long-term prognosis of capacity concerns, it's time to start thinking about these documents and asking whether they have them in place. The really important part about them is that what you're doing when you're creating these documents is you're appointing your decision makers, whether it's in a supportive way, for instance, in supportive decision making, or whether it's in a more, all powerful agent way with the power of attorney and personal directive, but you're picking that person. And at the very end of this presentation, I'm going to talk very briefly about what happens when you don't have these documents in place, because it's basically a court application. It's much more expensive, it's time consuming, it's more onerous. So when there's no one who can step up and put these documents into place, if they need to be invoked through a declaration of incapacity, then we are looking to the court to make that decision. It's also important when you're thinking about who you're picking, is that knowledge that you can change that person. They can be revoked if you have the capacity to revoke documents. So they do have this idea running through them of autonomy, and you selecting the people who step up and assist you with your financial decisions, your health decisions, or support you with a supportive decision maker. So who assesses capacity in Alberta? So for legal capacity, it's the lawyer drafting the document. So when a client comes into my office and they're looking to make a power of attorney and personal directive, I start with the presumption of capacity. And then I think, and if I need to, and sometimes I don't need to, it's kind of very obvious, but sometimes I'm dealing with clients who we've already talked about the fact there may be some capacity concerns. Maybe they've been told by their physician that they have a diagnosis that affects their cognition. Well, then I'm deciding at that time whether I'm able to draft documents for them, whether I'm able to say with confidence that I think that they have the legal capacity to enter and draft a power of attorney, personal directive. So that, to me, what that means is, do they know what they're doing with this document? Do they know what the document is? Do they know what it does? Do they know that it's giving the power away to someone else to make these important decisions if they were deemed to lose capacity? It's also about having a sense of the type of decisions that would be made under these documents and what that means when looking at their finances. So we understand from the legal perspective that a power of attorney requires a higher capacity than a personal directive because of the financial acuity that is needed to kind of have a basic understanding of your finances. At the same time, I have clients who they know what they have as far as finances, they know what the assets they have, they know how they work, but they do need help managing it, and they already have a trusted child, for instance, helping them out. That doesn't mean they can't necessarily draft a power of attorney. It shouldn't be a reason that they do not go to a lawyer and start engaging in that conversation because they're already getting help from their family members and their trusted family members. It just makes the process a little different. And I think in that case, going to a state lawyer who does incapacity planning documents more regularly is pretty important. In the medical world, capacity is something that is determined by physicians, capacity assessors, geriatric specialists. For personal directives, we can't put them into place on signing. There needs to be a declaration of incapacity. And as the person creating this document, you're the one who gets to decide how many people have to make that declaration. So for the most part, people pick one, but sometimes they pick two. Sometimes it's working with your agent. Our legislation allows for a little bit of creativity there. I'm not a doctor, I'm not medically trained, so I know little on that generally, and how to make that assessment. But of course, when we get to the litigation side, I'm working with a lot of those doctors. And these are just some of the ways that physicians and capacity assessors work to determine capacity, but it can be a very complex medical process. But MOCA testing, behavioral analysis, cognitive assessments, all those types of things. Legal capacity, and I touched on this already, it is presumed under legislation. So we start with everyone above over 18 has legal capacity to enter into legal documents. After that, it becomes task and time specific, and each document has a different test. So we think of testamentary capacity. It's kind of an easier one to understand because it's more set out in our legislation and case law, but this is the capacity to prepare a will. So at a really high level, what we're looking for when determining whether a client has testamentary capacity, and this has been set out in case law from 100 years ago, and it keeps changing and adapting, but at a high level, it's understanding what a will is. Do you know what it is to make a will? How it works, that it takes effect on passing away, all those types of questions. Does the client have an understanding of one's property? This doesn't mean they have to know every single dollar that's in every single account, but they have to have a sense of what they own and how they own it, whether they own it by themselves, whether they own it with their spouse, whether they own it with an adult child, whether they own money in trust or whether they have an income flowing from a pension. So these are kind of the discussions that I would have with clients at the outset. And awareness of who would normally receive one estate on death. So what this is exploring the relationships. You know, for the most part, there's a societal understanding that we look to children or family members to inherit. So if they don't have a sense of that, who might normally be sought, there may be an issue with testamentary capacity. And this one's a really textured criteria right now that has a lot of interesting cases about it. But it's used a lot when we have a will where a adult child is written out of a will in the last moment. So then the question is, do they know what that meant and the significance of that could have caused litigation? And no delusions that would affect making a will. So this one's a little bit hard to understand, but essentially you have to not have a delusion that affects something that would affect your will. So you can know that you might think that there's ghosts in your house or the moon is made of cheese. That's not really it. If you think that someone is stealing from you, or you have some delusion that affects your property or your relationships, that's where we get that factor being something that is as referenced when it comes to legal capacity. So the guiding principles, when we look at all of these documents, and I bet that many of them will resonate with you in the work that you do when working with seniors and our elderly population, is that we want to use a least restrictive approach. Autonomy is really important, self-determination, best interests. The makers, when I say the makers, it's the individual, the client who's making this document, their values, beliefs, and wishes. So these run through all of the documents, and they run through the court's decisions talking about them. They want the people in charge, so the attorneys and the agents, they want them to take a least restrictive approach. If an individual can contribute to what they want the decision to look like, they're supposed to be part of that conversation. We're supposed to remove the decision-making from individuals in a thoughtful way and not just in an all or nothing way. There's a lot of flexibility in the incapacity declaration documents that physicians use that allow for certain types of decisions to be taken and given to another legal decision maker under a power of attorney or personal directive before all of them. Generally speaking, financial decision-making and health decision-making are the ones that are considered to require the most capacity, because they have a short and a long-term requirement to think about the consequences of making a decision and the consequences of not making a decision. So those ones are really kind of thought of as the first ones which get checked off in those incapacity planning documents with physicians, so that such person appointed in those documents can step up and start making some decisions, hopefully with the individual, but also for the individual where required. So this is the same sort of idea. It's on a continuum, least intrusive to most intrusive. And that's how our documents are set up as well. There is not an all or nothing approach to this. So before I get into the different types of documents, I thought it might make sense, and this is probably not news to you, of just going through some of the things you might see in clients or in loved ones, which indicate there might be a capacity decline, and might, you might want to suggest to work with, talk to their doctors or talk to their family members, talk to their lawyer, whatever the kind of the thing is that they are missing. And these are also the things that I look for when someone comes to talk to me. If someone got lost to my office or struggling to find words, if they're difficulty concentrating when I'm trying to talk to them about their documents. Sometimes when I have children come, adult children with their parents, because of course, many people, need someone to drive them and help set up that meeting. I sometimes have some of that conversation with the children, assuming it's, appropriate to do so in the circumstances, recognizing also that the adult, the person doing the power of attorney, the personal directive is my client. But being aware that sometimes that information is really helpful for me to know whether I need to speak with any of their other trusted professionals. Sometimes I speak with accountants or physicians just to get their thoughts on this individual, to know what kind of risks we have creating a document which may later be challenged, which is kind of on that litigation side, which we won't get into today because it's a whole other area. But thinking about the fact that these documents are sometimes challenged, and they're sometimes challenged by the issue and the question being put to the court of whether they were made while the individual had the capacity to put them into place. I basically just said these things. Sorry, I'm kind of just going off the top of my head a little bit, but it turns out my brain is already on the screen. So yeah, early stages, these are the type of people who, at this time potentially should be engaged. Does the individual have their financial plan set up? Do they know where their assets are? Do they have short and long-term goals set in place? Have they thought about those goals, whether they've changed with respect to what their living arrangements might require with a new diagnosis or with a new trajectory from a capacity perspective? Executing and updating planning documents, again, really important. Exactly as I've said, if you've lost that capacity and we can't put them into place, we have to take other steps when someone needs that help. And that's to the court. Oops. We're seeing more and more of these, and I expect that you are. I have the EAAAC Staying Safe, a resource for older adults living in Alberta, on my desk here. And this is a great resource, and I've been looking through it because there are clients that I think really could benefit from this. And what we're seeing in the legal side of things is that more and more cases are coming across my desk where individuals with reduced capacity have been taken advantage of, whether it's predatory relationships, a will gets changed at the last, within the hospital. This sounds like it comes into movies, but it happens not infrequently with the caregiver gets changed and is the beneficiary of the estate. Financial scams, poor financial management, all of these things, they have on the other end often really expensive legal consequences to fix or to try and find out and put in places the type of court orders we need to do the digging, even to figure out if there's a way to get some of that, maybe it's a bank account that was put in joint names without the capacity to do so, to try to get that back so we can work with the whole of the estate, and that can be really expensive endeavor. So we're seeing it on the litigation side as being the consequence of well, basically people taking advantage of people. So in all of these documents, one of the first things we're doing, and I feel like this is always a bit of a teaser now because I'm going to talk about each of them separately, but the way I like to, they all have different jobs, right? We have an attorney, power of attorney, an agent, a personal directive, a supportive decision maker in a supportive decision maker document. And the reason why I put this on one slide rather than going through each of them is whenever I'm working with clients, I do try to understand them holistically and talk to them about all the different important people in their lives who they trust to make sure that they've set up themselves for success with their documents, but also that they've set up the people that they've appointed for success as well. We want to not appoint 3 different people who all can't get along at the outset. Let's hope that they at least are starting at a place where the agent, the person making health accommodation decisions, can work with the person who's making the financial decision. So the power of attorney, obviously financial acuity is pretty important. Knowing your values and wishes, really important as well. Those are important for, do I want to stay in my home? Do I want to have a certain type of healthcare treatment? Do I want to have a certain type of diet in the future? These types of things. So knowing those values and wishes is important for appointing people. We want good communicators because the job requires that person to be communicating with third parties on your behalf. So that's the banks, that's the care homes, that's the physicians. We also want them to be good communicators to you, right? They're supposed to act in your best interests and keep you updated. So, starting with that, they should be able to talk to you about these important things is a good indicator that they might be the right person to pick. So when you're talking to clients about this, figuring out who's in their court and figuring out who will work well to facilitate this and working together can be a really helpful kind of prep work before they speak with a lawyer, because I'm going to ask them these questions, and if they've already kind of thought about it, and sometimes people like to talk to their children, figure out who might want the job. Where they live can be a big one for some people, and will they accept the appointment? I mean, it doesn't make much sense to appoint family members or friends who won't take the job. If they're going to say, no way, Jose, then let's not even start there. I'll give you the tools to try to talk to them, talk about them, about what that actually looks like, or we say, who else is there, someone else? All right, now to the documents. Supportive decision maker. I feel like this one gets lost sometimes in the legal world. But most of the time I don't put this into place with people. We're doing personal direct and power of attorney. How if there is a possible capacity concern at the outset, I like to have this document put in place as well, because what it does, it allows someone to work with you, and you don't have to have a declaration of incapacity, but you've given them the ability to speak with your physicians, to speak with your accommodation provider. So this is that one that relates to personal decisions. So a power of attorney, you can put in immediately. So you're already able to appoint someone who can help you right at the outset. Personal directive, you're not. You need to have a declaration of incapacity. So this is kind of the I need help, but I know I'm not in a position, I'm not at a place where a physician's going to say, I can't make my own decisions, but I want someone to have easy ability to work with me, to come to my doctor's appointments, to come to write emails on my behalf, those types of really helpful things. So this is a document, unlike the other two that we're going to talk about, that the supporter actually has to sign off on. It's one also that we often see put in place in hospitals when a personal directive is not needed, and there's a pretty good. I don't have one of my own, for instance, of these precedent. I use the one created by our care system because it comes out from the legislation, and it works pretty well. And this is what they're using in in a lot of hospitals to kind of bridge that gap of a declining capacity without having to go right to a personal directive and putting that into place. So it goes to this least intrusive understanding of capacity on a continuum. So I've covered some of this, and I think I'll just touch on this last point here. If someone loses capacity and, if they're on the decline and the supportive decision maker is in place, well, what happens? It ends when the personal directive gets put in place. If they don't have a personal directive in place, and that can be enacted by one of their healthcare providers who fit that criteria of being able to enact those, then we're looking to the court to appoint either a co-decision maker or a guardian. So the guardian is kind of akin to the personal directive, and it's the court-appointed version of an agent. The court will, if there's only one person stepping forward that wants this job as guardian, and fills out the paperwork and applies to the court to be appointed, the court takes various steps to ensure and to investigate whether this is a suitable person. That includes requiring notice to other people who might be also thought of as an appropriate guardian. So if you had several children and one came forward as to want to be a guardian, the court there are service requirements for you to appoint for that individual stepping forward to let the other siblings know. They also need to have a credit check done on them. There will be a review officer who will talk to them. So because it's not the appointment, and then kind of the background of this, or I suppose one of the policy reasons behind this is it's not me appointing this person, it's the court appointing this person. So the court takes these extra steps to ensure that they are appointing someone. Whereas if I'm appointing someone in my document when I have capacity to do so, there's nothing really stopping. There's no check on that person at that point in time when they get appointed. All right, power of attorney. So this is the money one, and I know this is the one that we kind of, when we started talking about creating this presentation, Liz, we really focused on this one. And as we went through it, it is so important because the consequences of financial abuse are so significant, and they're becoming more and more prevalent with all the different types of scams, and they're more and more sophisticated. So it's on the rise. So these documents are more important than ever. But to me, they're one piece of the whole decision making of a person, which is why I always say power of attorney is the money one, personal directives the everything else. So everything else is a lot, but and really important things: medical decision making, accommodation. But the power of attorney focuses on money. So we talk about the estate. And that's a word we often think of when someone passes away, but it's also used to understand the finances and the property of the individual who is the donor and the power of attorney. This can be immediate or springing, which makes it distinct from the personal directive. A lot of people come in and they already want their son or daughter or their spouse to be able to go to the bank and assist them and be able to go on their own. Maybe they have some mobility concerns and can't go down to the bank. Well, power of attorney, we can put it in immediate. So it's just a matter of signing it, and they can use that document to work with the third parties. And the person you appoint is the attorney. So that's their name, which is just a confusing word because, of course, attorney is a name for a lawyer, particularly in any American television shows, for instance. And so it is confusing, but that person becomes an attorney, and they become a fiduciary, and they become a trustee. So they are given a role that's really important and has a lot of overlay of legislation, which we'll talk a little bit about, but that's why we want to pick someone who can, who's up for the job and can make good decisions for you. So financial capacity, this is where, if a power of attorney is springing, what capacity assessor is trying to figure out is whether you have financial capacity and the ability to make decisions, informed decisions about your finances, understand the consequences of making those decisions, and understand the consequences of not making those decisions. That's how we get to this idea of financial decision making. So these are, and I did go into the detail because this is a bit more of, I think, of many of your guys' scopes of practice, recognizing when some of the financial abuse is happening can be a time where it makes sense to have a conversation with clients if that's your role in your relationship with them, about talking to friends and families, talking to their trusted people to say, maybe you should have a document, have your power of attorney put into place and activated such that someone else can have that access. Another thing about when that person is granted that access is that they're accountable to you and they're in charge of making good decisions for you. So if they don't, there's potential recourse for you, recognizing you're maybe in declining capacity, but another one of your trusted family members could say, hey, is this attorney doing a good job? And there are certain routes through the court system where they can ask for an accounting, for instance. So it kind of adds that little bit of check and balances. So broad, what's the attorney doing? They have the ability to sell land. You have to be pretty express in a document about this. Selling land, of course, and to register land requires working with the land titles office, and they like to see that in the document. They like to see an express power to sell land, but you can certainly grant that power in your power of attorney. Spend money on you, your spouse, and your children, assuming they're dependents. This isn't adult children. This is minor children or any children you have who would potentially be considered a dependent, who you establish that dependent relationship with. They have to invest prudently, adhering to the prudent investment rules. They're not allowed to make risky decisions with your money unless you give them that permission. I'm allowed to make risky decisions with my money. My attorney is not. So there's a bit of a difference there. They also need to make sure that you are up to date with your tax filings. They can't let you go in arrears, right? Incur penalties with the CRA. They also have to meet reporting requirements. There's been a lot of changes at the CRA recently, which requires attorneys to potentially, and it's a little unclear depending on what type of property they're holding, report to the CRA that they actually have this role because they're trustee, as I had mentioned, in many cases. They also can dispose of your personal property if necessary, and continue to make gifts to charities if that's something that you've directed in your document. This kind of goes counter to the spend my money on me. So for the most part, when advising attorneys, I like to say, well, what does the document say? Are you given that permission? On the flip side, when I'm talking to my clients, do you want your attorney to still be able to donate to your favorite charities, to give gifts to your grandchildren, those types of things? It's better to be expressed and have that conversation with the client at the time of creating that document when I'm drafting it, when I understand that they have capacity and meet that legal test. Their obligations. This is the reason why sometimes people say no to this job, because it is difficult. So when talking to clients about who are we picking, what role, which one of my friends and family would be better for this role, it's good to think about some of these things. They need to act in your best interests. They have a duty of good faith and loyalty. These are legal terms, but they are legal terms, but I think you know what they mean, right? They have to act, think about what you want. They have to act for you above acting for themselves. They need to be able to keep track of your financial assets and accounting. They need to exercise reasonable care. They can't estate plan for you. So they can't go out and just all of a sudden redo your will. They can't act in a conflict of interest. They cannot benefit anyone other than you and your dependents, and follow your wishes, values, and beliefs. So this is something maybe that can be explored with clients, as if helping people find the tools of what to communicate their wishes, values, and beliefs to those people. Because if you don't know, if I'm an attorney and I don't know how to implement financial decisions with what your beliefs are, and this goes for the personal directive too, well, then I have to use my best judgment. So having direction of that from the outset is helpful. Of course, having discussions with your loved ones about incapacity planning is also difficult, and not everyone wants to do it. So, it's finding that balance of what people are comfortable with. So this is the salesy pitch part of it. Why are we doing it? Like, why should we encourage power of attorneys to be put in place? Why should we encourage clients to have this in their back pocket in case they have declining capacity? Is it gives someone the legal ability to step into your shoes and make those financial decisions when you cannot. And it can protect you when you're vulnerable, right? It's, you know, has someone who's keeping an eye, they're supposed to be, right? That duty of loyalty, keeping an eye on your finances. You know, sometimes they're setting up checks and balances with the banks, a limit at the withdrawal. So there isn't an ability or a ability to go to take large amounts of money out with the clerk without you being there. So kind of setting up some of those tools that we can work with third parties to protect vulnerability. And they're tailored for your situation. So we can decide, I decide with the client, when are we putting in this place? Are there any restrictions that we're putting into place? Also having that conversation about why we're doing it. And that's where I think that education is really important. And also, at least when I'm planning with people, really want them to have the tools to be able to speak with their loved ones about why they're doing this so that they feel confident having that conversation about their values and their goals. And the alternative is this trustee application that I keep foreshadowing at the courthouse. Running a non-contentious, meaning there's no fight over who wants to have the role if someone's lost capacity of trustee, can cost thousands of dollars to get all of the court forms ready. There are also renewal requirements, accounting requirements. And so those are not something that we see as a matter of course in power of attorneys. There isn't a requirement that you come back to court every 5 years and give all the finances decision-making to the court for them to approve it. That is something that the court can put in place and does if it has any concerns about the person they're appointing as trustee. We can put reporting requirements in the power of attorney, but again, it's done with the education with the client to figure out what makes sense for them with how they understand their finances and the individuals who they'd be appointing. Personal directive. So this is the everything else. Personal decisions not relating to money. Accommodations, end of life care. These ones really go to those valued beliefs and wishes in a more powerful way, I think. Do you want to stay? Does the client want to stay in his home forever? Does she want to not be a burden and go into a care home sooner? These are the types of conversations that I have. And sometimes it's the first time they're having them with anyone or even each other. So encouraging some, you know, and it's not something you want to talk about all the time, obviously, but it's something that if it's more natural to do, it's a little easier for me to do as well. If they've already kind of thought about what their goals are for living, do they want to stay in their home? Do they rather renovate their home and put in something to make the stairs easier or would they rather move out? And those are really big decisions for a agent to do. So the agent is the person you're appointing in the personal directive. And if the agent might think it's in their best interest, but the attorney might say, that's really expensive. I don't know if there's the money for it, or I don't want to spend the money on it, but if we have it in the documents and we have that discussion and we have the clients letting the people in their court know that this is these are their wishes and beliefs, it's much easier to find that and ground the decision-making in those past discussions or possibly in the documents themselves. Where you might live, who you might live with, those are the powers of the agent. Decide what activities you can do, end-of-life decision-making. Another one that comes up a lot is who gets to visit the individual, right? So it's, you know, who's allowed to show up at the nursing home and walk in, who needs an appointment. Those accommodation agencies will often have that discussion with agents. Another thing I haven't mentioned, and I'm sure many of you know this, but many of the long-term care facilities require these documents put in place or some sort of contingency planning in case if there's a lack of capacity or declining capacity, because they want the individual, if they have that declining capacity, when these documents need to be put in place, they want to know who to go to. They want to know who's the person who's going to step up and make the legal decisions, because in the alternative, they have to figure that out. You know, maybe it's a court application. So it's kind of a mitigating their own risk as well. But they'll often have some of those discussions with individuals about these documents and why they want them in place before that move into those care facilities. So unlike the power of attorney and the supportive decision maker, this one comes only into effect when you've declared incapacity. We use the word springing. So sometimes if we're looking at these documents, if one of your clients says, I have a personal directive, and you say, well, is it in effect? Well, what does that mean? That might not be very, we've already gone into the legalese and everyone's confused. So what you're looking for in the language of the power of attorney is saying it's either a springing power of attorney, or that you're looking for a language that says this document comes into effect by the written declaration of one doctor or psychologist working with my agent. So there's a language on the bottom of the page. There are the options that are set out in legislation. So if that's the case, so you look at the document and you're trying to help your client figure out whether this document's in effect, whether there's actually a different person they should be looking to help make decisions, or even make all the decisions for those personal decisions. It's look in the document, try to find this language, and then asking the question of whether has there been that written declaration. So has a physician activated this document, put this document in effect? Has a physician said expressly, like, the power of attorney is activated? So sometimes we'll have doctor's notes, sometimes we'll have a full capacity assessment report. There's different ways that physicians do this, but if there's also an indication that this document should be in effect, and it's, you're encouraging a client to go see their family physician, to see if this document should be in effect, then that's, and because you think it should be, you want to be able to use it because you want to be able to say there's another person here who has that legal decision making. That's where it's a direction to a physician to put the document into effect or activate it, so to speak. So same idea. Why are we doing this? It's giving someone that legal decision making, and with that legal decision making power comes obligations to act in your best interest. So on the litigation side, I see fights between children about what's in mom's best interest, about where she should live or who she should visit. So, again, it goes back to, I think, the documents allow us to tailor it to situations, allow you to think about, put some of your wishes in the documents, allows us to ground some of the concerns about what would be in your best interests, or what your value, how that would sit within your values and beliefs. And particularly end of life decisions and types of care are another one. And we don't usually, most of the time, I think, we're drafting pretty broad language with this because people like the flexibility of having, working with their physicians. And that's really who is really having these discussions about end of life decisions. But we can reference those documents if they filled them out to say, I have made myself, my beliefs and values clear on this because I've worked with my physician, and I want those to be also ones that my agent would follow. So some language like that to kind of incorporate this holistic and the partnership between the agent and the individual's other care providers. So the alternative is the guardianship application. So guardianship and trustee application, power of attorney, personal directive, they're akin. But the important thing, I think, again, it's the same sort of thing. You don't get to pick who that person is because they have to come forward to the court and say, this person needs a guardian. I want to be that guardian. What if there's two people who want to be the guardian and they don't want to be co-guardians? Then we have potentially a disputed guardianship application. And I don't even want to tell you how much those cost sometimes when we get really litigious mudslinging fights about who should have that role. And the court takes it very seriously. And again, it's the reference checks, it's review officers working with the individuals who coming forward and asking for that role, but also with the represented adult, which is the name of the individual who needs the guardianship and trusteeship within the legislation that governs guardianship and trusteeship. So the moral of the story in this part is it's about empowering clients at the outset, right? It's letting them put some of their beliefs in. It's having that education discussion about who they should pick, why they should pick that person. I really like to give tools to people to how to have conversations with their children. Maybe they think, I want to point all 4 of my kids because they would be upset if I didn't pick all of them. Well, and they all get along really well. I mean, I've heard that many times, and I hope it's true every single time if we've appointed 4, but I often recommend let's figure out who the best person is for the job based on skill set or where they live or how well they know you. And then let's figure out ways to talk to them so that, you know, it's not a surprise. So how can we kind of mitigate any of those disputes as between the various people who might think that they should have these important roles under a power of attorney or personal directive? So I kind of give a few examples today, but I kind of hammer back on this. It's important to talk to a lawyer because these are legal documents and have really significant legal consequences for the people you appoint, and also for yourself if you appoint, or for the clients if they appoint someone who's not, you know, not going to be great at the job or doesn't want the job, or the alternatives. You know, there's things like appointing American citizens is not usually, I try to avoid that for the power of attorney because it can cause some tax issues and complications. And it is personal, right? We are going down some deep dives of what if questions when we're in it. So it's a lot, but let's do it once and we'll do it right and with contingency. So it's not something that needs to be done over and over again, hopefully. So it's that taking the legal information that we talked about right now and kind of applying it to those personal experiences of clients and the people who I'm drafting for. I wanted to quickly just talk about undue influence because it has a specific legal understanding in estate planning, and it's one that's a very high threshold and has become very even higher in recent case law. But basically, it's coercion or pressure that overpowers a person's ability to make legal documents, such as they're not making their own decisions. So it's not the child who's necessarily influencing it from a legal perspective. It's kind of there's no other way in which the person basically had to sign this documents. So, you know, I'm always on the high alert for this, and it's something that on the other end I see quite a lot when we're looking at wills and looking at these documents to determine whether that will was done with capacity. Capacity requires, or drafting these documents requires that you were free of undue influence. So this is where I am on heightened alert when I'm working with a individual and they really want their son or daughter, their child to be part of the conversation. You know, the children are doing much of the talking. You know, I'm not afraid to kick that kid out of the room and have a conversation just with the individual, you know, kind of testing those relationships, asking those follow-up questions, reconfirming instructions, I think is really important. And it's, you know, sometimes it's a bit of an awkward conversation to kick out one of those the child or the friend who's assisting, and I recognize that those people who are assisting are really important to get them down to see me in the first place. And almost most cases, they're that really important role in getting these documents for their loved ones. But you know, I have to stay on high alert, and I really couch it as I'm looking out for my client. I'm looking out for the veracity of the document. Like I want the document to have integrity, and it has more integrity if I've had that conversation. And I feel confident that when I'm taking instructions, even though you've told me what they are, I want to confirm them with my client. And that's how I protect them to make sure I don't give an appointment away to someone who shouldn't have it. And sometimes that makes it take longer. And sometimes that makes the conversation a little more awkward or a little more sensitive. But to me, it's so important to protect. It's, you know, it's my ethical and legal obligation to do under my code of conduct and all those things. But it's about really just doing good work for people who are have some of those situations which raise the, you know, get me to raise the question a little bit more. So deteriorating mental and physical health, that's a sign of it, that you're kind of on the lookout. Isolation, you know, there's only one person that they communicate with, but there should be more, or there was more. The descendants give instructions and attend the meetings. So these are the children, or maybe it's the friend who the caregiver, creating that space between them. Sudden change. We look for sudden changes in gifting or appointments in legal documents, right? There's the same child who's been the appointed attorney and agent for decades, and then all of a sudden it's a new child. Well, I'm asking why, I'm asking for the background, and, you know, doing it in a sensitive way, but just in an explorative, curious way. But it's really important for me to have that information. And on the flip side, if something's challenged later from a legal perspective, I want my notes to be good. I want my notes to have that have that change. So these are, I think, things that I do that probably apply to your work as well. So this is a whole conversation on itself, but this is what I've been alluding to about guardianship and trusteeship. They have a piece of legislation called the Adult Guardianship and Trusteeship Act. I have it behind me and it's massive. And that's not even including all the regulations on it. And so it's a very technical piece of legislation, which great, really accessible for such an important thing. But basically, this is the legislation that guides that guardianship and that trusteeship. And that's why one reason why it's expensive. It's a little bit a niche area of law. People do apply on their own. The courts have many self-represented litigants who are bringing forward their applications for trustee and guardianship for their loved ones. They can get very contentious and be hard to navigate. And the justices are patient and in the process for the most part, but at the same time, they're difficult files and they often require a lawyer, and that makes things really expensive. So, the proactiveness of personal directives and power of attorneys is partially to avoid this. And one thing that I if it's, when I say it's expensive, well, it's like, who's paying for that? There is kind of a general understanding, and it's not every time, but sometimes, or at least I think we can say there's a kind of a presumption that if I as an adult did not set myself up for success, if I did not have these documents in place such that the personal directive and enduring power of attorney, if I did not have them in place, and consequently I've lost capacity, and now my 2 children are saying, well, I want the job, and they're fighting over it, and it becomes a $100,000 court battle. Who's paying for that? Sometimes it's the children who are fighting, depending on how they've acted in the process, but sometimes it's my estate, which maybe be the kid's estate eventually, I don't know. But if it's my estate, well, I was also the one who would have paid for the power of attorney and personal directive in the first place. And that can be really hard. And that's a problem sometimes when we have limited means as well. I mean, we're looking to that, the courts are looking at to decide who's paying for it. But if we can avoid that cost in the first place, that's certainly preferable in most circumstances. I kind of have just gone through this. We can do a whole presentation on it if we need to. It requires assessments of incapacity. It can be temporary, it can be flexible. The courts have a fair amount of discretion in it, but that can also make it difficult because they take that discretion with informed by what the applicants tell them. So that can be quite a onerous, long process to get that information out and to test that information such that the court is comfortable making a decision. All right, I fully have a broken record now about proactive planning. I've really covered this slide, and I think it's about knowledge and understanding that these are documents we have. They're not perfect. I'd love to see some changes in the legislation, but I think they're better if the clients know about them, are informed, and it becomes part of their agency to decide whether to put them in place, whether they're right for them, and who those important people are. A slight aside for dependent adults, so these would be individuals who could be some of your clients as well, those who have incapacity from birth or from an accident. And we're sometimes doing very different things when we're doing incapacity planning. We're doing ACE trusses, we're doing other types of court appointments. So there's a lot of specialized drafting we're doing. So again, if you have clients with a disability that prevents them from making their own decision making, whether it's a minor or an adult, talking to a lawyer to set them up with estate planning with that is pretty important. That's me, and that's how you find me. If you have questions or want to have any follow-up discussion on any of this, I'm happy to. My last plug for, yes, you can find these online and you can print them out, these documents. And sometimes people think, well, an online one is better than nothing. But I also sometimes go to court and fix the online ones, and that costs more too. So it is a very personal thing. And I thank the organizers today for letting me speak, because I like to soapbox a little bit about estate planning and being proactive. So I appreciate being the opportunity to do that today with you all. I think the remainder of my slides are your slides also.
Excellent. Yeah, thank you. So what I'd like to do now, I think Stephanie is going to just change the screen so we can take it off spotlight and then we can see all folks. I'd like to open up the room for questions. I know that's a ton of information. I was here taking notes like crazy. So, I mean, I don't want to take up all the time with my questions to Eleanor. So I'd like to open up the room for those of you who would like to put something in the chat, turn on your microphone. There's, I think, only about 20 of us in the room. So I think, you know, if folks want to turn off their microphone and ask a question, that's always a little nicer and a little more, you know, personal and organic than putting it in the chat.
I had a quick question. Thanks, Eleanor, for that presentation. I am working with a client and we're working on maybe a supported decision-making document. The daughter that she would likely name lives in the States. Is it required to have like a wet signature, or could we send it via PDF?
So that's a tricky question, and it's tricky because those documents, I might have to follow up with you on it because I want to look at how the AGTA clarifies them. They're technically under the AGTA Act and not under Personal Directive or Power of Attorney Acts. We do generally like wet signatures. Lawyers are dinosaurs, and that's just, we are the last to stop that. Even during COVID, I managed to do all of my signings on picnic tables, holding down papers on hoods of cars, just anything to kind of have that interaction. But the reality is that sometimes we can't do that. Sometimes we do think of creative things like shipping documents around through couriers to get those wet signatures. I don't at the top of my head know of any rule that means they can't be signed in counterpart. Or we do have, and I'm just trying to remember if they are actually in the form of an affidavit. I did one the other day and I can look at it and get back to you. But what we do have now is legislation that allows documents more easily to be, certain types of legal documents to be more easily signed in counterpart and virtually. So I can witness, for instance, an affidavit through a document, but it has quite strict requirements that requires that, and that vision of seeing it. And I think that actually now the supportive decision maker, now think about it, it's just a witness, right? It's not a commissioner or anything like that. Is that right, Elise?
Yeah, I think it's just a witness.
Yeah.
And I'm a commissioner, so maybe I could like watch her do it over video or something. Would that work?
Yeah, so what I have done in one I did recently, it's similar to you, and I can't guarantee it's going to work. But the important thing about those documents that I think make them fairly different and make the way in which third parties look at them different is because they're a consultation document, right? They're supposed to let someone help. They're different. They're not fully taking away legal authority. So what I did recently, and you know, maybe we can chat offline to see if we can think of something creative that works for your specific circumstances, but I did them in counterpart, put them together and wrote a document and had said on it, I witnessed these in counterpart, and I affirm that I kind of created what I would call a digital notary certificate and attached it with it, just to give it that extra kind of, the third party, that extra security that when they're looking at it, it's been executed properly, because that's what they care about, right? They want to make sure their liability isn't compromised because they've relied on something that wasn't executed properly in a strict form way. So that might work for you. Shoot me an email. We can be creative if we need to. Yeah, that kind of gets you there, I think, a little bit.
Yeah, thank you so much. That's really helpful.
Thanks, Elise. Does anyone else have any questions or comments before we just leave you with a few slides and some resources? I know Stephanie's monitoring the chat, so if anything comes up there.
There are some there.
Well, I think Rose had a question in the chat.
Yeah, so I think if you're talking about power of attorneys and personal directives, I usually witness them as the lawyer. They do not require a second witness in Alberta. Sometimes they end up doing that if people have property across the country to change them, because some provinces do require two signatures on them, but no, they do require a signature. They don't require the signature of the person you're appointing, which is why it's important that they know that they have this appointment and know this document. Supportive decision makers do require the signature of the person who you're appointing, which I think was a part of Elisa's point there is, well, how can I get all these people together in one room? That might not always be possible. Yeah, so usually I'm signing it. I'm also doing an affidavit of witness to the signature. So I'm going to another person and I'm swearing in front of them, affirming that I saw them and I think I had the capacity to do so, to give more veracity to particularly the power of attorney, because the stakes are so high in the financial decision making. I'm doing a declaration of legal advice, and then the clients are also doing a declaration that they understood the document, and I'm witnessing that as well. So we're doing lots, which is why is that big conversation. So not all those things would necessarily be required. And I say that because, we're relying on third parties and the knowledge of third parties to know that the documents are executed properly. So even if they're not executed properly from a legal perspective, yeah, maybe we can fight them. But, where are we creating other issues? I think that answers your question, Rose.
Yeah, thank you. I mean, because I was mainly thinking about people who actually make their own documents, so they're not going through a lawyer. If they're doing it,
They do. I think they do require it. So, if you want the witness, generally speaking, when anyone is witnessing any of these documents, if you've made printed one offline, I've given my spiel of why my preferences is done with a lawyer, but if they are being done on your own, a witness is always a good idea. It is required. The witness should not be anyone in the document. So it should not be someone you're appointing. It should not be the spouse of the person you're appointing. It should not be a minor. So those are kind of the big three that we're looking for. They need to actually witness it. They need to see them sign it. The execution of witness is pretty important as well. So that's that witness going to a third party to say, I saw them sign it. If we're ever testing the veracity of the document, those are things that can really cause some problems. And we have to kind of ask the court to forgive some of the things that didn't happen that made them like formally executed documents. So they cause some different issues.
Excellent. Thank you.
We have
And
one-
Deborah will,
Yeah,
Deborah
we have
will
one
take your
hand up.
question, and we'll move on to our resources and get everyone out of here for their day. Deborah, you have a question.
I'll unmute and lower my hand. Hi there. So I'm coming across these situations where I have an older adult and they have the only child or close family they have is maybe a child who, again, I struggle with the wording to be politically correct and everything, but somewhat of a lack of capacity for handling all the finances. Like the current lady I'm working with, Eleanor, when you were going through what the power of attorney needs to be able to do, I can't see him doing financial reports and stuff. So I don't know what to do. I want to provide the support to the senior. I'm now providing some support to the son who's 58. And yeah, how do you, what do you need to put in place? Because OPGT and all of that, that's a lot, and it's not a huge estate. She owns her house. Currently it's only in her name. He's been told by the bank that he needs to go to land titles and I mean, I'm not going to go into that personally. I will take them to, get some legal sources and do that. But I'm just like trying to figure out bits and pieces where I need to direct them, or how do I support these people, I guess is what I'm asking.
Deborah, that's a common and unfortunately common circumstance where it's one thing to say like, who are all the people in your court, right? And you'd be able to someone say, oh, I have all these people I can choose from. It doesn't happen all the time.
No.
And that's a really hard conversation to have with clients as well, because they're like, well, I don't have anyone. So sometimes, we're having a longer discussion and we're going through people. We're trying really hard to identify someone. And there's lots of questions I ask to try to tease that out. you know, sometimes it's, well, you know, who else would potentially be someone who would inherit from your estate? So sometimes that gets you to a family member that might not have been thought of, a kind of a
She
remote family
doesn't trust
member.
anybody else in the family.
Okay.
There's a niece and
Yeah.
a nephew, but she's got no use for any of them. It's
Okay.
like, oh boy.
Okay. So you had mentioned the Office of Public Guardian and Trustee, and you're right, that is a, you know, it's working with a government organization. They do require, like, so every single time I've worked with them to appoint a trustee, particularly, they want to know that in advance. They have to be part of the process. They have to be along for the appointment, and they're going to ask all those questions too. They try to figure out, is there anyone who can take this job? Because of course they would love more funding and they would love to have more resources of
Yeah.
their own, to provide more support for a population that is growing. And so public guardian trustee, I think, keep working on that. That's another route. Sometimes, every once in a while, I mean, it depends on the size of the estate. Trust companies will do attorney appointments. They are getting better. I was at a conference this last week in Toronto, and there are so many more trust companies right now, and they're looking, and they're taking estates that are smaller. So they take a good compensation, but you know, sometimes if it's the only option, we can convince a trust company to take an estate that's, you know, I mean, I'm
Yeah.
gonna say 800,000. Like, see, I know that's still a lot of money for some
That's a
people.
lot. Yeah.
Especially if there's no liquidity because everything's in a house.
Yeah,
I
exactly.
mean, yeah, it's hard. Like, it's a really hard decision. And yeah, sometimes it's, do we appoint someone and try to put supports in place for them? But you're right. I do really think it's about setting people up for success. And if the son isn't a good choice, you potentially cause more concerns. So I
Yeah.
don't have a great answer for you. But I mean, it's sometimes friends, like exploring friends, exploring other trusted professionals. So sometimes maybe they do have, sometimes lawyers take the job, or law firms take the job, not very often, and less
No.
and less. Yeah.
Well,
So it is
especially
really
again,
hard.
if
So
it's a small estate,
yeah,
not, you know, it is
yeah,
basically just the house, you know, so
yeah.
that's
Thank
about
you
it.
for your work. Thank you for your work, Deborah, because that is a hard discussion to have with your clients, because it's identifying, you know, it's really digging into what they might already consider as a gap in their, you know, their support network, and trying to figure
Yeah,
out who can we
yeah.
appoint.
And
Some,
I've already, I think, stepped on the son's toes a couple of times, so I'm trying to be a lot more conscious of that and how
yeah,
to go about it, and yet still make sure that they're both taken care of, because I mean, you know, he's 58, so technically he falls under a seniors category, even though he's not 65 yet. And so, you know, maybe she'll pass on and I'll end up with him anyway. So it's like, you know, so it's yeah, it'd be good to try and help get both of them on the right track. So that's what I'm gonna be working on. But yeah, it's only been a month or two, so lots to do.
you know, if it's new,
Okay.
maybe the relationship can be, you know, curated further and find someone else. But I wish
Yeah.
you good luck on that.
Thank you so much.
Thank you so much, Deborah. These conversations, I think, whenever we host a workshop or a session, we never have enough time. It can be an hour, hour and a half, 2 hours, 3 hours. So in lieu of time, and I know folks need to get going, Eleanor, do you mind just, I don't know if you're still sharing your screen. I just want to show folks, we were going to have a bit of a conversation around, you know, growing this conversation around, leading up to WEAAD. So I know folks are doing a variety, you know, there's a ton of stuff going on in your local areas. I'm going to skip through this and I'll just speak to the next slide. So I encourage everyone to really take a peek, you know, go online, ask your groups, your communities, you know, what events are taking place to celebrate WEAAD, what's going on this week for Seniors Week, you know, what are some ways that you'll be able to share this information and knowledge gained today, because as we saw, there's just so much information. And I think this conversation is so important to have, you know, and not once, and we may want to have this conversation yearly, you know, annually. So I think it's important to continue this conversation and think of ways that your organizations can come together to raise awareness on issues surrounding elder abuse. So I'd like to leave everybody with a slide of resources at the end. It should be the last slide. There you go. Thank you, Eleanor. So I know Stephanie had put, and maybe she'll put it one more time in the chat. There's a infographic that Charlene had spoke about in the beginning. So please take a look at that, as well as an amazing document put out by the CPLEA around planning for future care and enduring power of attorney checklist. You can print those off, share with your communities. So excellent resources to have. Thank you, Stephanie. And below, you'll see the elderabusea@gmail.com, as well as my email. And as Stephanie had mentioned in the chat, there is a brief survey. If some of you could please, all of you would be great, but if, for any of you that are still here and able to fill out that survey, we'll also send that out to all the participants as well. So I would just like to say thank you, Eleanor, once again, on behalf of the council, at CORE, Healthy Aging, and just the whole entire community in the province. Thank you so much for giving up your time and providing such an excellent presentation. I know we could have gone a lot longer and had some great conversations and dialogue around this, but everybody has Eleanor's contact information. If you want to reach out to me, and if you have any questions, we can certainly follow up with that. But once again, thank you so very much. And I will stick around for a couple of minutes. And I know Stephanie probably has a couple of minutes to stick around as well. So Eleanor, thank you so very much.